Good morning. Energy and Carbon Management Commission, day 4 of a big week. It's December 5th. It's 9:01. We will start with a roll call.
Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Ray, Commissioner Robbins,
Here.
Commissioner Rowan. Mr. Chair, you have 6 commissioners present.
Great. Welcome, folks, to the Energy and Carbon Management hearing. We are taking up docket 241000246, the Class 6 rulemaking. To set the stage, we started this on Monday, continued it to Tuesday. It's now Thursday. We've heard from all the parties, both their cases in chief, their closings, and rebuttals. We also had an opportunity to ask some questions of CDPHE in writing, and they have responded. Those questions and the responses are in the record. I would like to start this morning by having Hearings Manager Thomas read the questions and responses into the record so that everyone is aware of CDPHE's perspective.
Certainly. Question 1, is there anything that CDPHE would suggest ECMC do differently in its rules or SBP to address collaboration being done in accordance with 40 CFR Part 98, Subpart RR? The response, no. As commissioners noted in response to CDPHE's testimony, the collaboration called for in statute between CDPHE and ECMC is more appropriately addressed outside the context of the rules, such as through the suggested MOU. If commissioners feel strongly that the collaboration should be specified in the context of this rulemaking, CDPHE would recommend any direction on this be included in the statement of basis and purpose and not the regulatory text. Question 2, 350 Colorado recommended no permits be issued until CDPHE's carbon accounting procedures are in place. Can CDPHE provide an estimate for when those procedures will be completed? The response, as this Class 6 primacy rulemaking pertains to the siting and operation of Class 6 wells, not to the operations upstream of these wells, the carbon accounting procedures for estimating CO2 sequestered at Class 6 injection facilities are already established. As CDP noted in its testimony, 40 CFR Part 98, Subpart RR, which became effective in 2011, is the appropriate accounting method. In the context of using carbon capture and storage for regulatory compliance, which does include operations upstream of Class 6 wells, the Air Quality Control Commission has already directed that carbon accounting procedures be in place prior to the use of carbon capture or direct air capture for compliance with Colorado's GEMM rules for industrial and manufacturing facilities. AQCC Regulation 27, Part B, Section 3A1, and Part D, Section 3A2B, state that carbon capture and storage reductions may only be counted towards compliance after CDPHE's Air Pollution Control Division establishes a standardized carbon capture and storage protocol or set of protocols. These protocols will be on a comprehensive basis that incorporates energy and process-related emissions associated with capture, treatment, transport, and sequestration. Question 3, 350 Colorado recommended that data associated with carbon accounting be made publicly accessible. Can CDPHE describe how that data will be made available to the public? Response, CDPHE continues to advance transparency and has already created a new public-facing dashboard based on greenhouse gas emissions data reported by regulated entities per AQCC's greenhouse gas reporting requirements in Regulation Number 22. Additionally, facility-submitted reports and data are accessible via CDPHE's public access viewer. CDPHE intends to make data associated with carbon accounting publicly available in the same manner. And question 4, is the SCC a tool that can be used to quantify the environmental benefit of carbon sequestration on the local community where the well is located? The response, no. The The social cost of carbon is a per ton economic cost upon global society resulting from greenhouse gas emissions or benefit where such emissions are reduced. While local communities are part of society at large and are impacted by the emissions of greenhouse gases, the social cost of carbon is not intended to reflect specific benefits at the local community level. The social cost of carbon could only be used in the context of carbon sequestration to provide a quantitative economic benefit to society at large from the carbon sequestered. And that is the full question and answer document.
Great. Thank you very much. Again, that's in the record, but felt it was helpful to make sure that everyone heard it themselves because we have all read it and it will be influential to the work that we're doing. If we could elevate our staff at this point in time, I believe the next bit is going to give the commission an opportunity to ask questions of staff. I see you, Ms. Mercer. Okay, good. I see Rigby and Seeley as well. That's all great. Kind of initial question from commission to staff is we thoroughly appreciate, as we've mentioned before, the hard work that staff has done on this rulemaking. This is, in my opinion, at least a more subject matter expert rulemaking, and appreciate the good work that has led up to the November 20th draft. You guys laid out the November 20th draft. We've now and then the pre-hearing statements and responses were kind of pre that. And so a lot of it was not attended to that draft, but now we've heard from parties about that draft. And I just wanted to kind of ask an open-ended question to staff. Where do you guys stand? I really appreciate your knowledge and expert understanding of all this. Now that you've heard from the parties relevant to maybe some suggested edits or changes to the November 20th draft, do you have comments for commissioners in terms of where we ought to be thinking about that with regard to that draft? Mr. Rigby.
Thanks, Chair Robbins. Appreciate the question. And we also appreciate all the presentations by the parties and the thoughtful questions from all of you on the commission. I think generally to start, we do think the November 20th draft satisfies state and federal legal requirements. With that said, there were definitely some good ideas that would definitely add value to the rules from presented by the parties. I think as it pertains to permanence and the long-term permanent discussion, we know quite a few parties are concerned about that. We did find that Dr. McLaughlin's testimony was helpful on that point and agree with the statements that he made, that Class 6 regulations aren't intended to allow temporary storage, and that it's not very feasible path forward for any project. We do think, at least from our point of view, that the word inserting long-term into geologic storage is an appropriate solution to that, and primarily because it aligns with the federal standards of Class 6 rules that the EPA have in their regulations. We also, in clarifying applicability of the rules, KOGA's suggestion that the SBP clarify that the 1400 series does not pertain to the production of CO2 would be a good qualifier added to the SBP. For items related to community engagement, we really appreciated Green Latino's focus on these matters, and we do support a number of items that they presented. Adding plain language to our website where the rules will be posted seems to be common sense to us. We also support requiring the community outreach on testing and monitoring and emergency remedial response. And in fact, that edit was included in the November 20th draft already. And in general, I think our intent is to be as transparent as we can. And much, if not the large majority of Class 6 permit and project information will be publicly available, excluding confidential business information as required by Colorado confidentiality law. We also really appreciated the suggestion from 350 Colorado to revise 1406E to require a post-completeness community meeting. And this addition would make the rule consistent with cumulative impacts rules, which was our intent. From there, for 1410 pertaining to cumulative impacts, we do think some of ALG's blue lines would add value to 1410A. We're happy to give input on any of those particular items if you'd like. And as far as 1410D2 goes, we also agree that mitigation projects and community benefits agreements could be useful in determining whether there's been a negative net cumulative impact. In regards to preventing duplicative efforts for wells that have previously completed CI analyses as described by Carbon Storage Solutions, we do think it's possible to allow for substantially equivalent information developed through similar plans or efforts. This is allowed in other rule sets, but we would still want the leeway to require new or amended plans if the location or other circumstances have changed since the initial drilling. In regards to social cost of carbon, we don't have very strong thoughts on here. We do think it could be an interesting data point in a CI analysis at a high level, but we have not really discussed this thoroughly with our sister agencies, and so we think perhaps it could be addressed in guidance or further evaluated by the commission in the future. In the same regard, we think objective criteria could be useful, but developing criteria applicable to all situations and projects could be challenging. So again, I think we would recommend further evaluation there. The other, per the setback, we do support the, or 1411, which is the siting rules, sorry, not the setback. We do agree striking prior to constructing from 1411D would eliminate ambiguity related to if a surface, due to obtaining surface owner consent. So, and that was an ALG request, I believe. And we also think Carbon Storage Solutions suggestion to the definition of commercial building, excluding office buildings that are co-located with industrial facilities, is in line with the intent, and we think it would be a helpful clarification. Lastly, for induced seismicity, we appreciate the suggestion from Carbon Storage Solutions to clarify the 24-hour deadline when an incident occurs. We do think that maybe the SBP could be the appropriate place to explain the intent to be reasonable in the content of a specific project's plan and requirements. Those are really all of the topics that we flagged that we thought we would bring to your attention. We're happy to answer any additional questions.
Thank you very much, Mr. Rigby. Really, really appreciate the thorough analysis from staff on what we heard. My notes reflect 12 potential suggestions, some of which are suggestions to leave it as is and further evaluate, but really appreciate that. Commissioners, the staff panel is open for questions on any of these suggestions or any other items that may have piqued your interest from your notes that you took over the last couple of days. Commissioner Cross?
Thank you, Mr. Chair, and thank you, Mr. Rigby and Mr. Seeley. I really appreciate this because I know you answered many of the questions that I had. A couple additional questions that I wanted to ask about first. Number one, you talked about the statement of basis and purpose language that KOGA suggested. They had also talked about changing the definition to have the injection CO2 flow line. Did you have any thoughts on that language to make sure that it was separate in the rules as well as described in the statement of basis and purpose?
Sure, we don't have any necessarily any issue with that proposed language. We think the current language does adequately separate it because it references geologic storage operations. But if additional clarity is wanted here, we don't think it would, let's say, cause any issues.
Uh, that's helpful. And so one of the other things that I wanted to try and touch on, you went into a little bit, and that was not necessarily going with the social cost of carbon information that was raised by the Chamber of Commerce. Objective criteria, potentially, do you think this is this kind of situation where quantitative information could be provided in an application, but maybe we don't have a hard set of rules, and this is more of a case-by-case information you have could identify potential benefits to the area?
I think that summarizes well what we're thinking. I think quantitative data could be used in the decision making applicable to a specific project, while maybe the overarching decision is more of a qualitative decision.
And if I could just add on to that, complete agreement with your statement and Mr. Rigby's, because we are requiring a Form 50B that's modeled on the Form 2B, staff will be collecting a good deal of quantitative data related to cumulative impacts. So that will inform the qualitative determination that the commission would be making under 1410.
And then maybe we put something in the statement of basis of purpose that says if you have something beyond the 50B, then you can present that as well as, and it can be taken into account.
I think staff would be fine with that.
Okay. And then let me double check my notes here. Again, I think you answered most of my questions, so I'm going kind of on it. I know that you talked about thinking it's acceptable to look into community agreements and things of that sort. Are you suggesting that they be required for community agreements, or just saying, again, this is something that can be taken into account as part of the no negative net cumulative impacts?
Taken into account, not required, was the intent of our comments.
Okay. Initially, those were my questions here. Again, I think you answered most of mine, so I'm going to double check, but I think those are the main questions I had. Thank you.
Commissioner Oath?
Thank you. And similarly, which appreciate your overarching comments. They were very helpful. Couple of follow-up things. Thanks for your comments about the language about permanent and long-term. Kind of along the lines of the permanence testimony. Some of the concerns seem to be around, while not intended to, while not feasible, could technology change and circumstances change such that a Class 6 well may be tapped, I guess, in some way. And so what I'm wondering is, do the current regs as drafted, the draft regs, would they require in that situation for that well or an operator who wants to pull carbon out of a Class 6 well sometime in the future to come back through the ECMC?
And I may kick it over to Lauren for anything I miss here, but I believe at a minimum, they would have to update their plans on the project if they're changing things. Again, I find this horribly unlikely, but they'd have to return the main economic driver, the tax credit, if they removed any CO2. But and Mark, I believe, also might have some comments, but at a minimum, plans for how these would operate would need to be redone and reapproved.
Yes, I was just going to add on, thank you, that if there were to be operators who wanted to extract the CO2 back out, that would need to be part of the plan that was part of the Class 6 development application that was initially approved, or part of an amended plan that would still need approval during injection operations. So I don't think that operators or applicants could just come in and decide to extract it whenever they wanted to. It needs to be part of the approved plan by the commission.
Thank you. And then switching to financial assurance, this is an area where I would love your thoughts on some of the testimony we heard about some of the instruments that some of the parties would like the rules to allow by default, but the draft rules would allow that, but kind of more on a case-by-case analysis and at the director's discretion. Can you talk about kind of what concerns you have with those instruments and why you have proposed that approach as opposed to allowing them by default?
Thank you, Commissioner Oath. I can take that one. The sentiment from ECMC staff, including finance staff, is that self-insurance, letters of credit, and non-government backed securities may not offer the strength of a guarantee that the other forms of financial instruments offer that are listed in the rule. And so because of that, staff's preference is for those listed forms of financial assurance over the ones that were omitted. But as your question recognizes, Rule 1415A1F allows for, quote, any other instruments satisfactory to the director. And in staff's view, those instruments could include self-insurance, letters of credit, et cetera. So functionally, there might not be a real difference between the two approaches, staff's draft versus the standard EPA language that lists out all those mechanisms. But staff's draft should signal to operators that self-insurance and the like are not favored and could be subject to additional scrutiny by the director. So was sort of the thinking for removing those instruments, but they're removed from the default list, but they're still allowable at the director's discretion. But staff would, of course, defer to the commission if it's preferred to add them back to the list.
Okay, that's helpful. Thank you. Do you, would you have any concerns with requiring pre-application notice to the relevant and proximate local governments as suggested by ALG? Or is that one of those that you were indicated you would be comfortable with in their red lines?
So notice to the relevant local government is already required and consultation.
Okay.
There is notice also to the proximate local government, though I probably not pre-application notice and consultation. So that would be the difference. And I guess I would defer to Mr. Rigby or Mr. Seeley if staff has a real preference on that.
I don't think we have a real preference on this and would defer to the commission on what you all think here.
Okay. And on this line, Mr. Rigby, you did note that there were a number of ALG's red lines that you could support. And that you'd be happy to talk about that more specifically. Can you provide some more specifics around kind of what you're looking at that the staff thought, that would really improve the rules?
Sure, I can. Some of the edits provided, we believe the edit that the analyses should include the area of evaluation used, whether that will be affected, and I'm trying to pull it up here, so sorry.
Yeah. That's fine, and if you want to,
it would be fine. We think the source of the CO2 and proposed pipeline route is likely not appropriate, as we do not regulate these facilities. The EnviroScreen tool, we think that's a good addition. We do also believe that it might also be required, and Lauren, maybe you could clarify there that it's already maybe required by a rule that's adopted is to include an EnviroScreen analysis, but adding it here could just add clarity. The edits saying that are a narrative description of any adverse cumulative impact that the operator determines would result from approval of a Class 6 development plan. We think that makes sense. We also, I think there's an addition of any mitigation measures or community benefits agreements that were proposed or enacted is a good addition. I don't know if there's any others that you'd want to ask questions on, but that's kind of, I believe, the main edits and kind of our thoughts on those edits.
Very helpful. That is everything. Thank you.
Can I follow up on one question from Commissioner Oath, and that's the self-insurance letter of credit thing? Ms. Mercer, am I understanding that the way that staff would like this is to remove those as like particulars, but that they still exist in terms of the art of the possible at the discretion of the director?
Yes, that's staff's intent.
Okay. One other question. We'd heard from some parties that how this process works is oftentimes you go in and do a science well or a stratigraphic well first, sort of understand whether this is doable, and then you come in for kind of full permitting. The way I think it's drafted now, the science well or stratigraphic well requires kind of full-on permitting. Currently, how we've been doing it, at least with, I think, geothermal and others, is we've kind of got a standing order on science wells and stratigraphic wells. Is that working? Is that not working? What's staff's thoughts around that?
Thanks, Chair. One point I would make here is our rules actually in 1403 are very close to the standing order. So it is a process that's more like the standing order than a full hearing process for science wells. But there is a cumulative impacts analysis required. And correct me if I'm wrong there, Lauren, as part of it, but it is an administratively approvable process for the science well. From my point of view, that process is working to allow science to occur and data to be acquired to support these projects and determine if they're going to move forward.
Ms. Mercer, did you have anything to add to that?
No, Mr. Rigby covered it well, I think.
Thank you for those clarifications on that front. Other questions for staff? Commissioner Messner?
Thanks. I've got a few questions. Appreciate the clarification and the input that you provided. So just a few areas of I'm trying to better understand a couple of things here. So I wonder if you could opine on the kind of specificity of well casing materials and the understanding that at times they'll need to be updated and what the process would be to update it if EPA updates it, and how that would work within the current rules and or future rulemakings that may be needed to update any EPA specifications that may change.
Sure. So currently, due to Colorado law, as people have pointed out, we have to adopt the current regulations as they are. We have talked with EPA about this as it was a point they raised, and the solution contemplated is that we will establish this in our MOU with the EPA, which is required as part of primacy, that we would update through a rulemaking as necessary if federal regulations are updated.
And what do you, I know you can't predict the future, but what do you imagine the timing of that would be? Is it something like with the habitat maps where we do it annually, or, only when significant changes, or what would be the trigger, I guess?
I do not think it would be annually, but EPA does now and then update their federal CFR code. And if it would make our rules less stringent, then we would need to revisit. So it would be a case-by-case update. And if it has impacts on our primacy, I don't think it would be something that would be happening annually. It would be a 1 or 2 off here or there. And I don't know exactly how often, but I would almost guarantee not annually, because the feds do not update their rules that often.
Sure.
Yes, if I could just piggyback on that, I completely agree. And just based on my familiarity with the federal rulemaking process, it's a very slow process, significantly slower than ours. So if the EPA is going to undertake updates to the Class 6 or other UIC rules, we would have a lot of notice that that was coming, and we'd be able to start talking to EPA and getting plans in place to update our rules as quickly as possible after the federal rules were revised.
Okay, thank you. A couple other questions. I wonder if you could talk a little bit about the offset well analysis that would be done as part of applications and the sections of the rules that address that. I think there was a lot of concern in some of the testimony about kind of interference or interactions between either P&A wells or existing wells with the Class 6 injection well and the geologic storage area.
Sure, there are requirements within the area of review and corrective action plan that are required from permit all the way until the end of the project to identify any wellbores within the area of review. So that's the entire subsurface area where not only the CO2 is, but also where there is additional pressure that could pose a risk, and to remediate those wellbores to Class 6 standards if necessary, if, for instance, they penetrate the sealing layer. Many of these projects are, and actually this is a big driver why many projects do not plan to just go right into the middle of an oil field and put a sequestration project unless it's underneath the oil window where there aren't many penetrations. Because they'd be required to remediate every single wellbore that penetrates the seal. And it's to Class 6 standards with appropriate materials to prevent corrosion and to prevent them from being a conduit for flow. And if any well became any project a well, and this is any well, I should say, not just oil and gas, it could be a water well, it could be any well that it could be a conduit for flow, would need to be remediated and up to Class 6 standards to prevent any leakage out of the reservoir.
And if I may add on to that, Mike, just on your last comment of it, it really is every well bore. So whether it's a legacy P&A well from the 30s, 40s, 50s, 70s, or a water well, that is all part of the well bores that the applicant must address as part of their operation.
And just to clarify, that would also take place if there was any conversion of a Class 2 well or other type of well to a Class 6 well. Is that correct?
That is correct.
And then, so I understand, does the Class 2 well permit expire if it's converted to a Class 6 well?
That would be my understanding. If the Class 2 regs are no longer applicable and it needs converted to a storage project, it would be converted. It wouldn't be duly permitted. But I would flag this has not been done anywhere nationally at this point. And the EPA has not provided clarity on this process.
But your understanding as far as our rules go is that that class 2 permit would expire or evolve into a class 6 permit, and that dual permitting wouldn't be possible.
That would be my understanding as of today. I don't, yeah.
Okay. I wonder, because there was some questions about this, but I wonder if you could explain a little bit about Rule 1401A2, what review process that goes through. Does it go to hearing? Is it administrative? And how it relates to 1416B and 1417A. I know it's a little bit of a complex question, but
Sure.
there were some questions about this, so I thought it would be good to get your perspective.
Thanks, Commissioner. It's definitely not administrative. All Class 6 applications will come in front of the commission, regardless of if it's an existing well of any kind. So I'll start with that. The other part is that 1416B and 1417A is only applicable to other injection wells, not to the monitoring and science wells, although they're in the same rule. The newest draft really, I think, makes it clear that it's other injection wells that are existing. So those are wells that have been approved for injection, have a history of injecting fluids, have wellbore requirements that are already under the EPA standards per the Safe Drinking Water Act. And so this is actually a federal allowance for previously approved injection wells to, if they can essentially show data on their ability to protect USDWs in the context of a Class 6 project, do not have to abide by the specifics of 1416B and 1417A. And I think Mark has something to add on there.
Go ahead, Mark.
Yeah, it's not so much to add on to this, although it's part into it. I'd like to go back just real quick, if I may, and sorry for the kind of the casing material, et cetera, that needed to be done and regulations, et cetera. I think I would just encourage folks to be open to, it really is dependent upon the subsurface fluids, the right type of metallurgy and cement that must be used. And that's why, as part of the application process, that information needs to be gathered ahead of time to verify that that well is constructed appropriately. And so there are examples of CO2 injection wells for Class 2 or Class 6 being composed of steel, nickel, chromium, different types of metallurgy. And so it really is a site-specific, fluid-specific kind of metallurgy composition that needs to be analyzed and determined. And so just want to caution folks on really zoning in on one incident in the country and what that materials need to be going forward, because it can vary and does vary.
Okay. A couple other questions, just because there was testimony about it as well, just confirming that Rule 1403D is still goes through the hearing process and is not an administrative approval, or am I misunderstanding that?
1403 is only applicable to science wells, so that's not a Class 6 project, so it is administrative. But if you convert that well, it would go to hearing and through the whole process.
Okay, and that's only for the science well or data well?
Correct. If they're actually going to convert it for Class 6 use, it has to go and do the full development plan.
Okay, thank you for that. There was one ALG request, and I would like your thoughts on it. And it's regarding Rule 503G12 criteria to apply for a plugging order for the used or useful question, and whether that could or should apply to Class 6 injection wells.
We did include the portion of that request from I think a pre-hearing statement in the November 20th rules, as they indicate in their presentation, that applies to converted oil and gas wells. I believe you're talking about actually used or useful Class 6 wells. We think this is not a total right fit from staff's perspective, mainly because there's so many fewer Class 6 wells. They are really, a lot of investment goes into making these projects, and there could be specific project scenarios where you would shut in for maintenance, or if there is some sort of let's say issue with the source of your CO2 that it needed to be shut down for a while, where they would still intend to be returning. There is also a rule where once they have officially ceased operations, they do need to plug the well within 2 years. So we think the combination of all those kind of thoughts and requirements was why we did not incorporate that into the November 20 draft. And I think Lauren might have something to add here.
Sure.
Thanks, Mike. I'd also add, in addition to those safeguards, there's Rule 1413, which is the EPA rule we propose to adopt related to modifying, revoking, reissuing Class 6 permits. And this is a unique rule. We don't have anything exactly like it for the other industries that the commission regulates. And so it does give the commission or the director, depending on the circumstances, authority to require modifications or even revoke a permit based on certain changed circumstances and the like. So that's just another protection against the sort of circumstances that I understand ALG to be concerned about.
Okay. Thanks for that. So one of the recommendations from a number of different groups was to closer align statute CRS 6103 with Rule 1410D2 when talking about adverse and beneficial impacts by including the term environmental in there. So adverse and beneficial environmental impacts. Do you have any concerns with that?
I think staff would defer to the commission on that. I know by referencing cumulative impacts is what the evaluation here is. We'd be going back to the definition of cumulative impacts, which aligns with statute. So I think it's already done there, but would defer to the commission if greater specificity is desired.
Okay. Thanks for that. And I guess the last thing, just because I'm interested in your opinion on it. I'm balancing this long-term storage term with permanent being in statute, long-term storage being in EPA. Again, all the testimony from the stakeholders have acknowledged that permanent is certainly the intent. I think staff has all indicated that permanent is the intent. The benefit and disadvantage, I guess, of long-term storage versus permanent, following statute versus EPA. I'm torn on this one.
I guess is the question just what do we feel about long-term versus permanent?
Yeah, I'm just trying to understand the benefit of following the EPA term versus the benefit of following the statutory term.
I guess to add a little bit to what we said earlier, we do like long-term because it aligns with the federal requirements. I think as stated by one of the parties, permanent does mean infinity, and that is not something that's very easily regulated, and circumstances change into, the long distance future. So additionally, the CO2 is owned by the operator who injects. So we think their property right to their CO2 would be another item to think about in determining permanent and long-term.
Okay, and in the federal regulations under the term long-term, is there clarity on what long-term means? I think 50 years I've heard from EPA standard. 100-year is a length of time that's contemplated by the Colorado Energy Office, which I know doesn't have a regulatory piece in all of this. So help me with that one just a little bit so I better understand what long-term means.
I suppose I can tell you what I think it means. I do think long-term is, we'd have to be reasonable. It is long-term. Does it have an exact year? I don't think so, but it doesn't mean 1 year. I'll say that. So it needs to be reasonable in the context of the project, and these projects are intended to last, monitoring up to 50 or more years. So I think it's allows for some flexibility in interpretation, but puts a reasonable safeguard on the length of time. I don't know if Lauren wants to add on to that.
A little bit. It's just that in my read of EPA's regulations, I think long-term is something probably much longer than 50 years. Even 50 years is just the presumptive monitoring period. There's an assumption that you're monitoring it to ensure that the CO2 is going to remain stable for a long period after that monitoring period. So I think it's a long time, which is not very helpful. I don't think EPA has provided us good language on that, but they do speak in terms of geologic sequestration, which I think is generally understood as the intent to be a very long time.
Okay. Really appreciate you answering my questions. Thank you.
Just a qualifying question on that last piece. I think we heard from pretty much everyone that carbon capture sequestration is not a temporary thing. Am I accurate on that front? I mean, like, can you help define the words long term by establishing that it's not temporary?
I would say and support what Dr. McLaughlin said the other day, that there's no project thinking about intermittent storage here or temporary storage, and there's a lot of technical and economic reasons for that. But I think I would defer to you all if you wanted additional clarity there. But I think these projects will not be intermittently injecting and producing CO2.
Mr. Seeley?
And I would go back as part of the regulations that the applicant needs to state the various trapping mechanisms that the injectate will undergo in the subsurface. And so that leads more credence to the fact of it being longer term than what we're thinking. And I think the other point that I'll bring out is something that I said earlier, which is if the applicant or operator does want to extract in the future, because of commodity, something that's driving it, that will need to be part of the plan that is submitted and approved. And so an operator just can't go out there and decide to extract it.
Okay, thank you for the clarification. Further questions for the panel? Commissioner Ackerman?
Thank you, Mr. Chair, and thank you to staff. The majority of my questions have been answered by your initial comments as well as commissioner questions, but I am left with, I think, just one technical clarification associated with this protection of extraction use of Class 6 wells. The other issue that was brought up a couple of times associated with extraction was the potential to inadvertently produce hydrocarbons and then sell those hydrocarbons as a result in kind of a quasi, EOR type operation. Can you talk a little bit about your opinion on the potential for that kind of production and whether there are any existing protections if you do believe that production might exist?
From my point of view, hydrocarbons cannot be produced from a Class 6 project and sold. That is a Class 2 project. You would be doing enhanced oil recovery, and it would need to be approved through an OGDP and compensate your mineral owners and go through that process. And they would determine if there's minerals within the project through science and data gathering. And they would determine if they wanted to move forward with an EOR at that point and produce it, or you would have to condemn the minerals and make it a pure storage project without production.
Thank you, Mr. Rigby. So just to be clear, my understanding from your comments is that under the existing rules, you would not be in compliance with the terms of a Class 6 permit if you attempted to produce and or sell those hydrocarbons, right?
Correct. That is a Class 2 project and would need to be permitted as a Class 2 project.
Thank you. I appreciate that. I think, Mr. Chair, that's all that I had remaining.
Great. Other questions, Commissioner Cross?
Thank you, Mr. Chair. I did have one additional question, and that was going to go to one other thing that was raised by Carbon Storage Solutions. In Rule 1420, they suggested that there be a definition of minimum credible magnitude. Did you have any thoughts on that issue?
It's something we would likely want to. It is a term that's fairly widely used by seismologists. It is basically like the magnitude that can be measured by the equipment that is there credibly. But if there is we'd want to probably do additional research before putting some sort of definition on that to make sure we get it completely correct. There is kind of general definitions across the nation of what this means. With that said, we're open to it, I would say.
Okay. And one of the things that they noted in the presentation was they like the idea of making that consistent with Class 6 wells consistent with Class 2 wells. Do you think that's an appropriate way to do it, or do you think it's better to try and understand it a little bit more and kind of come back to that?
Class 2 regulations are a little different, but the Class 2 regulations are not open for editing in this rulemaking. We do think that this strategy is appropriate for Class 6.
That's helpful. Thank you.
Really helpful discussion with staff. I think all commissioners are very appreciative of this. Any final questions? All right, I don't see further final questions. Stick around. We may have questions as we move into deliberations. I believe I would like, and maybe some other commissioners would like, a little time between now to kind of finalize our notes and get back together. It's 9:55. Maybe we could take a break until about, 10:15, 10:20. Gives us 15, 20 minutes to kind of go over our notes, and then we'll move into deliberations. Let's return at 10:20. Okay, welcome back, commissioners. Energy and Carbon Management Commission on the Class 6 rulemaking. It is 10:20 on December 5th. We are back. We've heard from staff this morning. A good Q&A session with staff was really helpful. At this point, I think we move to deliberations on the Class 6 rules. I'm not inclined to close the record because whenever we do that, we end up needing to reopen it because we then want to ask somebody another question. So not that we're looking to hear from parties, but we may need to hear from staff and or otherwise. Does anyone want to begin deliberating? Commissioner Messner.
Thanks. So just to better understand how I'm approaching this, I do take to heart the comments that were provided by staff and provided by the Colorado Energy Office and the statement that the rules as drafted, in their opinions, meet the legislative directive, meet the requirement of the EPA, and they're comfortable with it. And so my suggestions that I'll make are relatively discreet, and I think maybe reinforce some of that intent and direction that was provided in the rules. And so I think you'll note I'm not looking at big, broad changes. I also note that staff provided us a couple of items that they asked us to make determinations on. And so I did focus on that as well. And those in particular were around the application of the no net negative adverse cumulative impacts. And so a few different things here. I mean, again, my intent is to follow the general intent of the rules and to follow the legislative direction that was given to us with guidance by the EPA. In my opinion, we get our authority from statute and from the legislators. And so that's my primary direction. And then understanding that we also need to that we intend to get primacy from the EPA. And so they're an important piece of this whole puzzle as well. So my first comment is that I think we really need to clarify in the rules that this is permanent storage as intended by the legislation, the statute. I'm not opposed to the utilization of the term long-term storage as it perhaps better aligns with some of the EPA language as clarified by AAG Mercer. But there's still some squishiness or wishy-washiness in some of the comments that were provided. And I think that just has to be really clear that the intent for this is to be permanent storage, that it's intent to be injection, it is a sequestration, it is storage, it's not designed or developed. Whether or not it's economically or technologically feasible at this point to do it or not, that is not the intent of our rules in the Class 6 injection framework to use it anything other than permanent storage. And so language in the SBP would be helpful to really just hone in and clarify that. And then the addition of the language, long-term storage, I can be comfortable with based on the reasoning of staff today, but it really needs to be clarified all through the statement of basis and purpose in the rules that the intent is for permanent storage. I also think in Rule 410D2, to better align with statute, as I asked the question to staff, that the utilization of the term environmental becomes important because that is a term that's used in the definition of cumulative impacts, and ultimately we're applying that definition within these rules. And so adverse and beneficial environmental impacts in Rule 1410D2, I think would better clarify what the expectation is and how it's going to be evaluated. I do get concerned when we kick around these ideas of social cost of carbon or economic benefits, because that opens a can of worms that is really difficult to quantify and even qualify as far as potential benefits, because not only does it bring in the potential economic beneficial impacts, but it also then brings in the potential economic impacts associated with it, whether that's a drop in property values or other considerations that this commission has never grappled with before, nor do I know that we have the authority to grapple with some of these things. And so I think that the environmental piece in the cumulative impacts definition really clarifies how we're going to be evaluating these applications as to their cumulative impacts. I also am looking for consistency between, and I think that the rules do a good job of this, but I'm looking for consistency between the recently done cumulative impacts rulemaking and these rules. And I think as much as we can create parity between those two is helpful. And so my recommendation would be to change the trigger for the no net negative adverse cumulative impacts evaluation to be a mile in disproportionately impacted communities, as that's the same as the alternative location analysis and other items that we determined in the cumulative impacts rulemaking. And so to me, that makes sense. Just to stay consistent with that, understanding that the area of evaluation for the no net negative adverse cumulative impacts, no net negative adverse cumulative impacts. That is to be determined by the applicant in their application, and I agree with the staff and ALG's recommendations that should be identified in that evaluation, what that area of evaluation actually is. I agree that in Rule 1411, which was an ALG suggestion that staff agreed with, that the initial term in there, eliminate prior to constructing for surface use agreements, should be strucken from the beginning of that, just to create clarity. I think that there's a lot of things that the ALG brought up as staff agreed with in Rule 1410 that can be helpful in just better clarifying how we're evaluating things and what the expectation is for the applicant as far as what they need to provide in Rule 1410. As much clarity as possible in there, I think, just helps us from both an applicant standpoint to understand what they need to provide, and then from a review standpoint, what we need to be evaluating, how we need to be evaluating that. I like the recent draft's inclusion of the more clarity in the mitigation hierarchy. I would add that clarity just for belt and suspenders in Rule 1410C. And I think the 5-step process for evaluating that ALG came up with, while I don't know needs to be directly applied into the rules, is a good framework for how we would look at and evaluate the no net negative adverse impact in an application, and could be a useful thing to include in the statement of basis and purpose to really provide clarity on how we're looking at these things and the steps that we're taking in order to evaluate them. I appreciate staff's clarity as to when there would potentially be a rulemaking to make changes if the EPA made changes in some of their requirements, and I'm comfortable with that. And I also am comfortable with staff's explanation around the used or useful and the checks and balances that are available in the rules as they are drafted now. And I think that those are the main changes that I'm intending to suggest here right now. I have some more specificity in the Rule 1410 piece, but I think staff's highlighted the main things that I would bring up as well. So I think that, the inclusion of some of the ALG suggestions in Rule 1410, and if we want to go a little further into that or get more specific to that, I'm happy to do it, but I think I'll leave it at that right now until I hear other commissioners' thoughts on that. So that's my initial thoughts. Oh, I did forget one thing. I am also okay with the KOGA suggestions around the clarification of that these rules don't apply to carbon dioxide that is produced versus injected from a pipeline standpoint. And I mean, that makes sense. I think that's the intent. I think if we need to take steps to clarify that, I'm okay with that. I also agree with staff's suggestions around plain language and community outreach, the post-completeness community meeting, the mitigation projects, community benefits agreement, the Rule 1411 citing, the commercial related facilities, those I would agree with as well.
Thank you for kicking us off. Commissioner Oath?
Great, thanks, Mr. Chair, and agree. Thanks, Commissioner Messner, for kicking us off here. Happy to share kind of my initial thoughts on these things. I guess the first category I'll talk about is that no net negative cumulative impact area. There's a couple of sub issues in my mind under here that I have some thoughts I'm happy to share. First, one is, I guess, what I'm calling the kind of proximity trigger, or kind of, if a Class 6 well is proposed to be located X distance from RBUs, et cetera, in a disproportionately impacted community, that the analysis that, we will be evaluating whether or not there's no net negative impact. The proposed draft is for that to occur when well would be within a half a mile. We heard some other proposals. Appreciate where you're coming from, Commissioner Messner, in terms of consistency. And I might be getting myself all wrapped up around in this, but as I've been thinking about it, both the new cumulative impact rules and these rules would require a cumulative impact analysis to be done basically in all cases, right? So for all new OGDPs, as well as for all Class 6 wells, I think the case here is that there's this added layer of, and the statutory directive for us to make sure that any proposed Class 6 well would not have a net negative impact, cumulative impact on a disproportionately impacted community. I think the term area of review is something different than the area of evaluation that we talked about in the cumulative impact rules, right? The area of review here is kind of referring to subsurface and where the carbon is expected, given the geology of the subsurface, where the carbon is expected to migrate to, kind of like what's the pool. Whereas in the cumulative impact rules, we were talking about an area of evaluation being not a proximity trigger, but more of how far out from a working pad surface could potential impacts be that such that that's the area of evaluation for those surface impacts. So I'm already struggling with they're not quite apples to apples in my mind to compare and find consistency. And then the other thing that is on my mind here is some fairly significant differences, I think, in terms of for OGDPs, where we'll be looking at the cumulative impacts analysis and that area of evaluation. it's to consider both kind of short-term impacts during drilling as well as during production, longer term, whereas as you know, as we've heard testimony about here for the Class 6 wells, the impacts are during drilling, but then once the well has been drilled and completed, there are not ongoing surface impacts. So I do see that as a pretty significant difference. So right now, I think where I was landing was that I thought a half a mile made sense for that provision. And those are some of my thoughts around why. We also, I've been trying to decide on this issue of whether how we should be considering pipelines and whether or not we should be considering pipelines. And I understand where parties are coming from with respect to that. But I struggle with bringing that into our thinking for a number of reasons, and particularly I'm struggling with how really we would do that. Sort of the implication was that we should think about where a pipeline might be, given, the layout of where a well is proposed to be sited and how it relates to a community and where the carbon would be coming from. And I think there's a lot of unknowns, number one, about where that pipeline, what the options might be that are well outside of our area of expertise, our jurisdiction. And even if there were a scenario where the pipelines had been planned, I'm trying to think about how would we take that into account? And I think the implication was just that qualitatively we would be assuming that that's a bad thing. But again, that's not in our area of expertise or jurisdiction. And so I don't think we would be well informed to know what those actual risks or impacts would be. So I'm struggling with seeing the clarity on bringing that in, and would be leaning against making any changes in that regard. I appreciated the testimony and the conversation with 350 Colorado and a little bit from staff as well on qualitative versus quantitative for kind of this overall analysis. I think it is appropriate that this is overall a qualitative analysis in the event that a Class 6 well is proposed within a disproportionately impacted community. But I appreciate that a lot of the information that will be provided in the cumulative impact analysis will be quantitative, and expect that when it can be quantified, that will be information that we'll have to be able to consider in an overall qualitative analysis. In terms of economic factors, as part of the consideration, I agree. I think it is the case that because the statute indicates that any proposed Class 6 well that would have a net negative cumulative impact must be denied. And because cumulative impact is defined to include environmental factors, I think that we should be clear that we do not intend to consider economic factors as part of that analysis. I would be in support of Commissioner Messner's note of adding the word environmental to the regulation. I also think it would make sense to add some statement of basis and purpose language, kind of laying that out, that given the way that the statutory language is and how cumulative impact is defined, that we do not intend to consider economic factors in evaluating whether or not there's a net negative cumulative impact. With respect to the testimony about the social cost of carbon, I really appreciated the follow-up from CDPHE on this. I think that makes sense to me, that it is not appropriate to use that social cost of carbon as a way to quantify the environmental benefits to a local community near a Class 6 well. So I will state that for the record. I maybe would also suggest some statement of basis and purpose if others are in agreement with that. Moving on to other topics, agree that it's important for us to clarify the intent that storage be permanent. I too am in support of adding the word long-term into the regulation. I would be fine also with Commissioner Messer's suggestion to add some statement of basis and purpose language around this. Moving into a couple of thoughts on community engagement. Agree and appreciate 350 Colorado's suggestion that we should require a post-completeness community meeting. That will make the rules more consistent with the cumulative impact rules, which was the intent. Appreciate all of the testimony about the importance of the community liaison being involved in this process. I think that the November 20th draft hits the mark on that and is appropriate. We heard some requests to extend the public comment period to 90 days. In general, I'm in favor of, making sure there's robust opportunity for public notice and comment, which I know we all are. But I did want to note here that, in my opinion, the draft, which already requires 2 community meetings, as well as now this third post-completeness community meeting, and that really gets at this, that those are really an opportunity for meaningful dialogue and an ability for potentially affected community members to understand a proposed well, and don't think that just adding additional days during the public comment process is the way to get at making sure that folks are who are potentially impacted are aware of the project, are aware of any issues, have had an opportunity to voice their concerns and participate. So I would be supportive of leaving those as they are proposed in the November 20th draft, with just the addition of the post-completeness community meeting. With respect to financial assurance, I think where I am right now, I appreciate the dialogue on this with all of the parties. I think that the November 20th draft does allow for a pathway for a party to come in and utilize the additional financial assurance tools upon making a showing to the director that they are appropriate, and that makes sense to me. Then just a couple of things with respect back to 1410. Those red lines proposed by the ALG, I do agree, and I think these are the same. I think these are the same ones that staff noted, basically including that the commission will consider the area of evaluation used and whether disproportionately impacted communities will be affected by the proposal and how that determination was made. The EnviroScreen information, how the operator engaged with the community and the mitigation that's proposed. Provided a narrative information about cumulative impacts, as well as the mitigation measures and community benefit agreements that are proposed to offset negative impacts. To be clear, I would not be suggesting, given my previous comments, that we would add the proposed provision that we would consider information about the source of the CO2 in the proposed pipeline pathway. I do think that it'd be great to clarify, as suggested by ALG, that we would provide pre-application notice to relevant and proximate local governments. Agree with the clarification that office buildings that are co-located with the well do not count as commercial buildings, which would require a 2,000-foot setback. And I think that's the end of my initial thoughts. Thank you very much.
All right. So what I'm hearing are kind of some specifics from Commissioner Messner and Commissioner Oath. And where I'm going with this, and I'm not trying to offset further deliberation, I'm just trying to provide us some direction. What I think is going to be the preferred pathway, and if AG Mercer might show up, that would help, is to provide this direction, since we are making some edits, even if they're discrete, to staff, and then allow staff an opportunity to craft kind of a final draft for our consideration so that we can all see it. And if that's the approach that we're taking, then for myself, Commissioners Cross, Commissioners Ackerman, we might want to start deliberations with kind of like me too on Messner and Oath, or me not on some of the suggestions from Messner and Oath, so that we can start to get a sense of where the collaborative direction is going. A.G. Mercer, are you comfortable with kind of that process in terms of where we might go? I mean, we do have some more time now because we've got produced water is no longer on the docket. So we could even move into, next week to return with the draft.
Yes, Mr. Chair, staff would be comfortable with that approach, and would request until at least Monday, if we could, to turn a draft.
Sure. Yeah. Okay.
And to the extent we could perhaps, I like your idea of going through, having the commissioners respond to things, and then if maybe staff could have a little bit of time once you've all deliberated to go through our notes and make sure that we've captured all of the points of consensus and verify those with commissioners before we disconnect. I think that would be best.
Okay, so we'll continue with deliberative thoughts. We'll try to focus in on consensus areas. You're taking notes on it. I'm also taking notes on it. Maybe we'll break for lunch or something, and then we can come back and you can say, okay, here's what we think we heard, and here's what we're going to go draft. And then we'll give you the thumbs up, and then we'll break until Monday or Tuesday or something.
That sounds great.
Okay. Who's next? Commissioner Cross?
Thank you, Mr. Chair, and thank you, Commissioners Messner and Oath, for kind of leading us off here. And with respect to what Chair Robbins just said, I tried to adjust my notes so I can kind of hit the I agree on those kind of things there, and I think I've done most of it, but hopefully I capture that in what I'm going to say. I think I've tried to kind of go by rules here, but I think there's a couple issues at the end that I think are maybe some of the bigger issues that I'll address at the end. But I think beginning with definitions, Koga brought up the injection carbon dioxide flow line and the injection carbon dioxide changes to definitions. For those, I do think that the addition is prudent, but not necessary. I agree with staff that the application of geologic storage facilities highlights that the rule does not apply to production flow lines, and perhaps the statement of basis and purpose language suggested by Koga is sufficient. However, for clarity, I'd be in favor of including that language that Koga provided in red lines. Same thing with the injection carbon dioxide. I think for clarity purposes, the red line is appropriate, but the statement of basis and purpose language could be sufficient as well, depending on what other commissioners think. I know Commissioner Messner brought that up at the end as well. Rule 1401, carbon storage solutions, asks for statement of basis and purpose language about not revisiting EPA decisions, disfavoring application of retrospective ECMC requirements, and variances being available for prospective ECMC requirements that are more stringent than EPA's. I believe those statement of basis and purpose provisions are appropriate. Rules 1403 to 1405, carbon storage solutions raise the duplication of review. I would note that Ms. Merlin, on behalf of Wild Earth Guardians, commented on this concern as well. I agree with what staff said this morning. I think it's appropriate to utilize substantial equivalent information, but allow staff to be able to require new information as well, not just say, well, this was provided before. And so I think it's especially appropriate to allow staff to require additional information if something has changed. And I do think that this is consistent with what we did in our cumulative impact rules with respect to CAPs and ALAs as well. And so I think that what staff mentioned this morning is appropriate for that. Next, I have Rule 1410A. As we looked at ALG's discussions of the area of evaluation and the EnviroScreen, as Commissioner Oath mentioned, I do think that those are appropriate. This was also mentioned by staff. And also I agree with staff and Commissioner Oath that we should not be including the proposed pipeline route and the source of the CO2 there. I also agree on the inclusion of discussion of mitigation measures as raised by ALG, including potentially community agreements, but don't believe that community agreements should be something that's required as a mitigation measure, but I think it's something that can be taken into account. Also raised by staff this morning, the plain language that was brought up by Green Latinos. I think this is appropriate. Financial assurance. I have no problem with including the additional instruments, financial assurance instruments that was raised by Oxy. Currently, I understand that they may not be the favored one, but I think the way it works currently under our financial assurance rules is if staff has any kind of concerns with the financial instruments, if they have any kind of concerns with the financial stability of any of the companies, it's kind of commonplace to just say, we recommend denial, let's have this go to the commission. And I think that's an appropriate way to do that. I think it's fine to include those financial instruments and say, and maybe in the statement as basis and purpose, say, staff, if you have concerns, we recognize that this may not be the favored method of financial assurance, but I think that this is appropriate to be raised to the commission if there is some kind of concern with that. And so I'd be in favor of including those instruments in Rule 1415. 1420, I raised with staff this morning as well, the discussion of the minimum credible magnitude. I think per staff's clarification, this is a term of art that may not need to be defined. I think that clarification in the statement of basis and purpose is appropriate to provide some background. But given staff's comments, I don't think it's appropriate to provide a specific definition based on the current information we have. As Commissioner Messner noted and staff raised, I agree on the striking of the prior to constructing. I agree with Commissioner Oath that we don't need the 90 days when we already have the community meetings. I don't think the additional timeline there is necessary. I think we do have, similar to what we did in the cumulative impact rules, we have built in a lot of involvement with the communities, and I don't know that the 90 days is appropriate. Couple additional statement of basis and purpose points that I had before going into kind of the two bigger issues. One, I think it's appropriate to clarify that confidential information is important and it won't be publicly available. I know there was some discussion, I think it was with Carbon Storage Solutions, that there's probably nothing in the rules right now that suggests that that might be what is transparent and publicly available, but I think it's fine to clarify that in the statement of basis and purpose. Also, I think it's, as was noted by my fellow commissioners before, the clarification on commercial offices that was raised by CSS and also commented on by Mr. Sir on behalf of ALG and Larimer County. I do think it's appropriate to make that clarification so there's not any confusion about that. That brings me to kind of the last 2 points that I wanted to touch on, and that's the permanent versus long-term. I do think that this is a difficult issue. As Commissioner Messner indicated, it's clear based on the testimony we had, based on what we've heard from staff, that we are referring to permanent storage. But I also do understand staff's concern with deviating from the current EPA language. I think at this point in time, I'd be in favor of sticking with long-term based off of staff's recommendations, but clarifying throughout the statement as basis and purpose that this is not meant to be used for switching later on to an EOR, that this really is meant for permanent storage. And I think it's what I've kind of grappled with a lot over the last few days here, because I understand what Dr. McLaughlin was saying as well, that it doesn't make any sense. It wouldn't be reasonable for people to try and go back and try and do an EOR with this. And so I don't necessarily understand why we wouldn't just say permanent, but as I mentioned, I do think that staff's concerns identified this morning and the desire to stick with what the EPA has already done, I think is appropriate. So I'd be fine with leaving it as long-term instead of permanent. And that brings me to kind of the balancing and the information that's brought in. I agree that we should not require the social cost of carbon. It's a formula that's used for global impacts, not local impacts. And as Ms. Merlin indicated, there's a variety of ways in which it can be calculated with widely varying outcomes for it. And I think such a subjective formula is inappropriate for the purposes identified. I believe it was by the Chamber of Commerce. I agree with Commissioner Messner that economic impacts can raise a lot of additional concerns, such as property values, which again can be hugely subjective and difficult to quantify. Thus, mandating such information is difficult, if not impossible, to create a clear regulation in what has to be included, what must be included. And so I don't think that we should have any kind of mandate about what should be included there. I think that this concern overall, I want to note that this highlights my concern with any no net negative standard, whether it's this, whether it's the no net negative impacts, adverse impacts that we talked about with our variance process. Currently, I think ultimately you're comparing apples to oranges. And in our current variance process, impacts to a resource can be evaluated by no net negative impacts to a completely different resource. The way it talks now, we say the variance is okay or could be okay as long as there is no net negative impact to public health, safety, welfare, environment, and wildlife resources. So we may be talking about wildlife being impacted, but as long as there's no net negative impact to FSWE overall, then it's not going to be a problem. And so I think that ultimately that's a concern that I have with this kind of standard. If you may be comparing NOx emissions to greenhouse gas emissions, you may be comparing one VOC to another VOC, you may be comparing one resource to another one. And I think here you could be stuck in situations where you're saying, well, there's a surface impact, and now you're trying to compare that surface impact to potential environmental benefits from carbon removed from the atmosphere. And so I find it difficult to do that overall. And it becomes a very subjective decision. And I think that as a commission, it's important that we have the capability to make that subjective decision and determination. Thus, I think it is appropriate to look at benefits that a project can have. I understand with what was raised by my fellow commissioners, this obviously should focus on the environmental impacts and the environmental benefits. And I think this can be really done in two ways. First, as described by staff in response to my question this morning, there's a lot of quantifiable information in the Form 50B. And I think that you can look at that information and say, here's some of the impacts that can be provided. But I do think that applicants should be able to describe benefits that can be provided as well. And I recognize that the import of this should be on environmental impacts, but I have no issue with raising economic benefits as well. That said, I think you need to simultaneously have potential economic impacts that are negative that can be raised by people as well. As Commissioner Messner mentioned, there are oftentimes arguments that having a certain project may impact home values. And so I think if an applicant is to come forward and say, we're going to create jobs in the community with this, or we are going to be able to have some other sort of economic benefit for what we're trying to do, I think it's entirely reasonable to look at the negative economic impacts that could be done with it as well. And I think that this is an area that understanding it's subjective, and I think that's where, as adjudicators, we have to be able to make that decision to say, someone alleging that there may be negative impacts to housing values. If they just say it, I'm going to be able to take that and say, well, but there's specific information provided here, but there it's just kind of a statement without any kind of support for it. And so I think that's one of the things that as a commission, we should be able to see. We should be able to assess the credibility of the information and testimony provided, but be able to look at the benefits, both economic and environmental, recognizing that the focus should be on environmental benefits. But it's something that we should be able to do in our evaluation. And I think one final note on that, I think it's important that if you only look at environmental impacts, it can become very difficult, if not impossible in a lot of situations, to even be able to reach that no net negative impacts that we're talking about. Because if you're looking at a situation, it's very different from the situation with some of the applications we even saw yesterday. Because in a lot of them we saw yesterday, you're looking at applicants that are plugging and abandoning a large number of legacy wells. And so there's going to be a lot of emission reductions from the decommissioning of facilities, the plugging and abandoning of wells. In an application like this, you're not necessarily going to have that. We're going to be storing carbon, but you may be looking a lot at, all right, well, there's the drilling impacts, there's a surface impact that's going to be there, but you're not necessarily looking at offsets from wells. And so I think if you don't look at some of the other potential impacts, it becomes very difficult to try and create any kind of apples to apples comparison in what kind of reductions you're having and how you are reaching a no net negative cumulative impacts. So I will say that that's one area that I think I somewhat disagree with the prior comments made, is that I think we can look at the economic impacts. I don't think that it's something that should be mandated. I think it's something that can be provided by applicants, but I think it's important that we make sure that we leave our capability to look at that information, recognizing it's subjective, but being able to look at this in a holistic manner to say, on the whole, are we having no net cumulative impacts from this application overall?
Thank you, Commissioner Cross. Commissioner Ackerman?
Thank you, Mr. Chair, and I appreciate my fellow commissioners and leading off and me having the opportunity to make a few comments. I think we've had a great discussion during this rulemaking, and I think we have a good set of rules with significant improvements resulting from the ongoing input as intended in our rulemaking, including input offered today. I have a few global comments, and then I'll follow that with just a few specific comments. And I wanted to say I really do appreciate the significant expertise and engagement in this rulemaking. I'm always impressed by and grateful for the high level of understanding and engagement in our processes, and I find it very helpful. That said, on one hand, we've heard from some stakeholders that CCUS is an important tool, and specifically that it can be an important way to sequester locally produced carbon to achieve net zero carbon emissions, and functioning as a significant tool to help the state meet its greenhouse gas emissions goals. But on the other, we've heard from others opinions that CCUS isn't a technology ready for deployment. They've highlighted concerns that its purpose is simply to enable the continuation of fossil fuel production. These are two polar arguments, and I just wanted to make a statement that it's difficult for me, at least as one commissioner, to see some significant movement forward on climate-based solutions proposed and then championed in the legislature by some groups. And then later, when we get to a rulemaking, they're denounced as not viable approaches, and those are by groups with related missions. And I just want to make a statement that I find that difficult, and I know that we don't come to consensus on legislation often in the state, but I think when we're talking about statewide programmatic mandates such as this, it makes a lot of sense to see what we can do before that mandate is handed down to us. And I suspect there was significant work on that front, but just wanted to voice my frustration with that point. Nonetheless, we've been given a statutory mandate from the legislature to implement a carbon storage regime to help achieve the state's climate goals. And CCUS efforts to attempt really are an attempt to address consistent demands of Coloradans to reduce CO2 in the atmosphere. And we've had some significant focus on locally produced carbon. I wanted to say that I really appreciated staff setting the stage together with the AG for this rulemaking. I think it was very important to the public, and wanted to reiterate, and to the commission, wanted to reiterate that what we had here were largely EPA mirrored rules. And I won't go through and enumerate those as staff did. And then we had some additional Colorado proposed rule subjects, which were, in my view, largely supplementary. And then, because it's a legislative mandate, we had specific statutory mandates. And then, subsequent to those statutory mandates, some additional ECMC rules to kind of supplement and implement that legislative intent, and also to ensure general compliance with the act, which is larger than the intent of this mandate. I do agree with keeping the federal portions as similar to the EPA rules as possible. It makes a lot of sense to me. our mission is broader than just underground drinking water protection. And so I can't really discount associated staff proposed protections that make sense. And I wanted to state that I do understand and I agree with the argument that really overly strict rules certainly can provide a significant disincentive to the establishment of this industry in Colorado, and arguably that could administratively thwart the charge with which we've been entrusted. So as a result, to me, a balanced set of rules is very, very important, both for protection in the way we do things in Colorado and for the proper establishment of a climate storage regime as we've been mandated. I think staff has done a very good job in its latest draft, and think that we've had significant help from stakeholders, both prior to the hearings and throughout the hearings and up to the modifications discussed this morning. With the further suggestions from commissioners, I think we're landing in a pretty good place. So, Mr. Chair, rather than kind of going through and stating agreement with things that have been said, I do have just a few comments that may be some points of clarification for where I'm coming from, where we maybe have seen a few diverse comments from the commission. And otherwise, I do agree with staff's inclusions as detailed this morning and appreciate my fellow commissioners' detail-oriented comments, and I'm largely in agreement with what they've presented as well. Because we've had some discussion about permanent and long-term storage, I would just add my opinion, which doesn't really diverge that much. I think I'm in a similar place to everybody else. I believe the intent here is permanent. I do get the desire to go as much as possible with EPA language. We do have to, pass a stringency review with them. I would therefore lean towards the long-term term, with elaboration on that term in the statement of basis and purpose. And I believe, Chair, you suggested maybe further even defining that term. I do think the statement of basis and purpose might be a good place to really set forth the intent that I think we've all expressed, both I would state from the industry and from environmental groups and from staff and from the commission, that this is intended to be a permanent storage solution, excuse me. I did want to point out really the only substantive wildlife issue raised during this hearing, which was raised by the tribe with regard to the Bruno Agreement area consultation and their request for notification. I wanted to note ECMC's strong relationship with the tribes. We believe we have a great working relationship with them and wanted to directly address this request. This is a very, very unique situation. This is a 150-year-old agreement between the tribe and the federal government, which vests them with hunting and fishing rights in a relatively large portion of southwest Colorado. Wanted to point out, though, that that's a right of use. There's no jurisdictional authority granted to the tribes through that agreement, but rather a right of use. As such, I think notification to the tribes in this unique situation is appropriate when there is development of this type taking place within the boundary of the Bruno Agreement. But I wanted to clarify that I wouldn't extend that to a mandatory consultation, but rather just a notification and opportunity for the tribe to participate in the public process. And I wouldn't intend for that to grant any special legal standing, but simply a notification based on these unique circumstances. As we've talked about the no negative impact standard, this is, I think we've kind of touched on how difficult this is, but important to what we're doing here, and certainly a mandate in the statute. And I certainly think that we'll need to continue to examine and address this issue as the system deploys and evolves. I fall more along the line of where Commissioner Cross is coming from on this one, with regard to not considering economic factors and adding environmental to the definition. What I worry about, and I'm kind of more along the lines of some statement of basis and purpose clarification on our intent here. And I do worry about the negative implications of the inclusion of specific terms or the exclusion of specific terms in this process, especially since we're talking about community agreements associated potentially with the implementation of this concept. I think that evaluation is intended to be holistic, and I'm a little reluctant to place any real hard sideboards on communities that may want to raise positive or negative impacts of any sort, be they economic or environmental. With that, I do agree that I think that what we're talking about here is largely environmental. I'm not super opposed to including that term, as I do think that's the primary intent here. But I do want to be careful about that definition and not necessarily be over-inclusive or exclusive of terms for the reasons that I've talked about here. That said, Mr. Chair, I think we've had a great discussion. I am in agreement with the other concepts that have been raised by fellow commissioners. And if we need to deliberate further on any of those for clarification, I'm certainly happy and prepared to do that.
Thank you very much, Commissioner Ackerman. By my notes, it seems that the only area where we've got a little nuanced disagreement is that last point you just raised, Commissioner Ackerman, which is the inclusion of environmental or not inclusion of environmental. I think what I'd like to do is call for an executive session. I think this is a legal issue that I at least would be better educated if I had an opportunity to hear some confidential legal advice from our lawyers. Hopefully you guys would be okay with that. Normally when one commissioner wants an executive session, I generally just go ahead and grant that. AAG Davenport, would you be willing to help us get into that after we hear from Commissioner Messner?
I just want to point out that I saw Commissioner Ray raise his hands. He may have some thoughts before we go into executive session.
Commissioner Ray, I'm sorry, I did not see your hand.
That's okay, Chair. Thank you, Commissioner Messner. I'd just like to make one deliberative comment, and I think it maybe makes more sense to do that before the executive session. First, I want to acknowledge all the hard work by ECMC staff on these rules and appreciate their expertise. Also want to express appreciation to the parties and other stakeholders that participated in the process. I think their contributions throughout the process have strengthened the rules. I do want to make one comment on an issue that was raised by a few parties. There were parties that requested that operators be required to contribute to a state fund for the monitoring and maintenance of geologic stored locations after the post-injection site care period. And I want to note for those that are listening that the department is pursuing a legislative proposal in the 2025 legislative session to create a new state enterprise that would take on responsibility for long-term monitoring and stewardship of Class 6 facilities after site closure. And the proposal is that that enterprise would be funded by a fee on operators. So the department is interested in establishing this new enterprise to complement the rules that you all are considering. And we believe that the legislative proposal, not this rulemaking, is the appropriate venue to establish that long-term monitoring and stewardship approach that goes beyond the protective regulatory requirements that are created by these rules. So I just want to encourage stakeholders that are interested in that we're currently taking stakeholder feedback on that proposal. I would encourage any interested parties to participate in the process of developing that proposal because we think it's an important complement to these rules. Mr. Chair, I just wanted to make that note and otherwise express the department's support for these rules and appreciation for the work of the commission to develop protective regulations that support the state's energy and climate goals. So thank you.
No, thank you, Commissioner Ray. Appreciate your being involved with us on this and bringing in the Department of Natural Resources stance as well. All right, with that, AG Davenport, you want to help us go into executive session?
Thanks, Chair. Yes, I'm happy to do that. I would like to suggest that the statement or the description of what's going to be discussed in executive session be broad. In other words, simply to receive legal advice and analysis on any legal issue presented in the course of this rulemaking, so that if the commissioners would like to ask additional legal questions, we don't have to leave executive session and state a new purpose and then come back. Is that acceptable to the commissioners?
So moved.
Okay.
Motion and a second to go into executive session for the purposes as described by AAG Davenport. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. All right, folks, just if you're not familiar with the script, the commissioners will leave this Zoom meeting. We'll go into an exclusive Zoom meeting for just commissioners and our AAGs. I do not think this is going to take a ton of time. When we're done, we'll come back here. So, probably, I don't know, 20, 30 minutes. So with that, just stick around and we will show back up when we're done with the executive session, and then we will finalize at least the initial deliberations would be the intent. So commissioners, I will see you in executive session. All right. The Energy and Carbon Management Commission is back in regular session. AAG Davenport.
Thank you, Chair. Commissioners, we just met in executive session, and I should have noted before we went in that that was pursuant to revised statute 246402-3A Roman 2. The purpose of that executive session was to receive legal advice and analysis on legal issues presented within this rulemaking. The Commission only asked legal questions and received legal advice. The Commission did not deliberate, vote, or make any decisions in the course of that executive session. And with that, Mr. Chair, we need a motion to exit the executive session.
So moved.
Second.
Motion and a second to exit executive session. All those in favor signify by saying aye. Aye. Any opposed? All right, we're back in regular session on the Class 6 rulemaking docket. We have heard initial deliberative thoughts from all the commissioners except me. Getting to go last is a pleasure here because I'm generally in agreement with where I see my other commissioners. The only area that I think we still have some nuanced difference of opinion. Well, first off, on the long-term versus permanent, I'm of the camp that we use long-term, which is the EPA term, but that we elaborate in the SBP that what we mean there is permanent. And then with regard to the issue on whether we include the word environment on the no negative impact, I believe in my mind, we should just follow the statute on cumulative impacts, which says public health and environment. And then we're being more consistent with statute. I guess I'd like to call on AAG Mercer to daylight. My notes show that we've pretty much got consensus with regard to direction, but my notes don't count. Your notes count because you're the one that's going to be doing the drafting with staff. Do you want to roll through anything? Do you want to take some time, come back after lunch and roll through stuff with us so that we can make sure we're all on the same page? What do you prefer?
If we could take a lunch break and then come back and confirm, that would be great.
Okay, before we do that, looking around for further deliberative thoughts from commissioners, questions, anything else for the good of the cause before we take a lunch break. Commissioner Oath?
One thing I'm not sure if we have consensus. I think that I had indicated for the proximity distance for the net negative cumulative impact that I supported the November 20th draft. Commissioner Messner, you had said a mile, and I don't recall if others weighed in on that. So just so staff has clarity on which direction we're going on that one.
Right. Commissioner Cross?
Thank you, Mr. Chair, and thank you, Commissioner Oath, for reminding me about that. I am in favor of using the November 20th draft of the rules as is. So just leave it.
Commissioner Ackerman, thoughts?
I concur with those thoughts.
I do too. So we'll go with the November 20th draft on that point. Anything else? Really appreciate commissioners deliberating here. appreciate all the stakeholders' involvement. I think we're getting to a good spot for CCS in the state of Colorado. It's 11:51. Let's maybe return it. AG Mercer, is an hour and 10 minutes enough? Returning at 1?
Yes, Mr. Chair, thank you.
Okay, let's return at 1 o'clock. Okay, welcome back. This is the Energy and Carbon Management Commission. We are taking up the Class 6 rulemaking. It is December 5th, and it is 1:01 p.m. in the afternoon. We had left this morning's meeting having provided deliberative direction from commissioners to staff. And I believe that next up is we will hear from AAG Mercer with regard to kind of a synthesis of the direction to make sure that we're all on the same page. And then for purposes of stakeholders listening in, I think the idea would be to then allow staff to go develop the next set of discrete edits to the rules and the SBP, turn that around to us and our stakeholders for final consideration at a hearing to be determined next week. AAG Mercer.
Thank you very much, Mr. Chair, and thank you for the lunch hour to review our notes on commissioners' statements and see where everything stands. If it's okay, I will share my screen in a moment. And so what I prepared while I'm getting this up is, here we go. My intention is to run through my notes of changes that were requested by the commission. Items highlighted here in yellow are where staff feels we need a little more direction. But this captures everything that we understand we've got direction to change in the draft rules or the SBP. So it doesn't mention areas where we heard, looks good, no changes. Of course, once I get to the end, if anything's missing, we would definitely want to hear that. So starting from the top in the 100 series definitions, we got direction to add the words long-term to the definition of geologic storage and explain in the SBP that the intention is for permanent storage, not temporary. So it would be a revision, as you can see, where I've highlighted there. As to the definition of commercial building unit, we understand that we are going to specify that offices co-located with an industrial facility are not commercial building units. There was discussion about defining minimum credible magnitude, but we believe the direction there was not to add a definition to it, rather to explain in the SBP that this is an industry term of art and will be applied as it is recognized in the industry. One point that I believe Commissioner Cross brought up, but we didn't hear from the other commissioners on, was whether to take KOGA's red lines to injection carbon dioxide flow line and injection carbon dioxide. So we would like further direction from that from the commission. I believe Commissioner Cross said he would be okay with SPP clarification or changes to the definitions themselves. For what it's worth, I think staff's preference would be SBP clarifications, only because these are statutorily defined terms that we are using. And so the less we can change language that the legislature gave us, sort of the easier it makes things on the back end when there's a legal review to make sure that our rules comply with statute.
AG Mercer, do you want us to deliberate on each of the yellows as we get to it, or do you want to go through the whole document, or what's your preference?
I'm totally open to the commission's preference, so whatever you'd prefer.
I mean, either way is fine. I'm comfortable with staff's idea of putting some SBP language in there, given your point about the statutory definitions. I'm only one commissioner. What are others thinking? Commissioner Cross?
Thank you, Mr. Chair. And as I said during deliberations, I am fine with it being done in the statement of basis and purpose for the reason that the statutory language has that as well. I think if anything, we could even explain in the statement of basis and purpose that that's why we are not putting that in there. But I think as Mr. Rigby said, with the reasoning for it, today as well from staff's position. I think that it makes sense with the geologic storage. So I think statement of basis and purpose is fine. I just thought I'd raise it to see if commissioners felt differently.
Anybody with a different thought? Okay, direction given.
Okay, thank you. Moving into Rule 1401, I believe we had consensus that we should clarify in the SBP that the 1400 series rules do not apply to the production of carbon dioxide, but rather only to geologic storage. And then another point that I believe we heard from Commissioner Cross, but not other commissioners, was a suggestion from Carbon Storage Solutions to add explanation in the SBP related to the applicability of the rules to pending permits with the EPA. And in looking back at their presentation, I believe we already covered each of the points they raised with regard to SBP language, except for a request that we add language that application of retrospective ECMC requirements is disfavored under the law. So we're interested if the commission wants that added to the SBP.
Commissioner Cross, do you want to elaborate your thoughts on this point for the fellow commissioners?
No, I just thought that they were the discussion we had was appropriate, and I think that as was raised, and I think when it comes to the variance and it's kind of a unique situation, I think, first of all, because I think there's obviously only going to be a couple of these that would be applicable to, CSS being one of them, but making sure that we're not retrospectively applying the ECMC stuff there, I think is appropriate. And so I thought it was valid points that were raised by CSS there.
Commissioner Oath?
Thanks, Mr. Chair. I guess I'm trying to still understand what this would mean. And again, certainly want to be working closely with CSS on this. I know and appreciate that we've included a number of elements already. Like what does this mean? Application of retrospective requirements.
AG Mercer?
So I believe, and I might look to AAG Davenport to fill in the blanks if I leave any, but the request is for a statement that is really just a statement summarizing Colorado law that says retrospective application of statute or regulations is disfavored. Generally, a principle of administrative law is that new regulations are to be prospective. So after they're enacted, they apply to conduct in the future. I believe CSS is looking for more clarification on that point, and I see that AAG Davenport has illuminated, so I'll pass it to him.
Yeah, thanks. AAG Mercer, Mr. Chair, Mr. Oath, is it okay if I go ahead?
Yes.
Okay, thank you. Just a kind of point of nuance on this, the word retrospective has a specific legal meaning, and it's not the same as retroactive. A retroactive application of a statute or regulation is to apply that statute or regulation to actions or pre-existing things that took place prior to the statute or regulation going into effect. Some retroactive application is legally acceptable. Retrospective is a particular word that's applied to unconstitutional or unlawful retroactive application. So the nuance here is that some retroactive application is legally allowed, some is not. And the stuff that is not is called retrospective application. I question, this is my personal opinion. I'm not sure of the utility of adding this to the SBP.
Let me frame it another way, AG Davenport. given the nuances that you just articulated with regard to the law in this arena, I, for one, am not inclined to put something in the SBP that might undercut, undo, have unintended consequences relative to those nuances. So that would be one commissioner's position. Commissioner Messner?
I would agree with that. And I think the other elements of CSS suggestions around variances were already captured in the November 20th rules. So I'm not sure anything needs to change here.
Any commissioner with different thoughts? Okay, direction given.
Thank you, commissioners. Moving on to Rule 1405, we believe we have direction to add language stating that substantially equivalent information may be submitted for a Class 6 development plan requirement where that analysis has already been conducted for a science or monitoring well under Rule 1403, with the direction that we craft such language that still allows us to require new analyses and information when that's warranted. So it'd just be permissive for allowing substantially equivalent information. Moving to 1406, one item we got direction from everyone on is to revise 1406E to ensure that the trigger for a post-completeness community meeting aligns with the cumulative impacts rules. So it's required anytime a location is within a DIC, as well as within 4,000 feet of a building unit. We got direction to leave the public comment period as it is in the November draft. And then one point that I believe Commissioner either Oath or Messner raised, but I'm not sure we heard from others on, is to add pre-application notice and or consultation. I wasn't sure on the specifics for proximate local governments. I would note that proximate local governments are required invitees to the pre-application community meeting, so they will be receiving pre-application notice in that form. But consistent with the other commission rules, there's no requirement of pre-application consultation with proximate local governments.
Commissioner Oath?
Thank you. Appreciate the follow-up on this. I think I did bring this up, and thanks for that flag. My intent was notice, and so given that they are invited to the pre-application community meeting, I think that from my perspective, that's covered. So I would be fine with no additional changes.
Commissioner Messner?
Just a question. I guess my understanding that proximate local governments were invited for consultation at a pre-application meeting.
So, it's actually, I said it a little too simply. So for pre-application consultation under the cumulative impacts rules, which we've incorporated here by reference, you can either do your pre-application consultation pursuant to 301F, which was the existing authority for basically ECMC to join in on a local government's pre-application meeting. 301F doesn't specifically require that proximate local governments be invited to those meetings, though I understand that's practice, at least in Weld County. I'm not sure where else. 301G, which is what applies if there's not a local government pre-app meeting that satisfies 301F, 301G does require that the proximate local government be invited. So to the consultation. So there's typically going to be consultation with the proximate local government if it's under 301G. If it's under 301F, it is not a strict requirement of the rule, but that seems to be the practice.
So for me, for consistency, it makes sense to I mean, if it is a proximate local government, it's within 2,000 feet of the site, it should be invited or have notice and invited to pre-consultation, a pre-application consultation meeting. That's in line with our OGDP rules, and so it seems appropriate for this particular rulemaking as well.
So and just to clarify, with the rules on consultation reference the OGDP rules, so they are consistent. What I was describing was my understanding of the OGDP rules, but I could
So
be.
I'm confused again then. So what are we talking about here? So if there's a notice, there being noticed that there's a pre-application meeting and consultation, you've referenced the community meeting in this one and not the pre-application consultation. So I'm not sure what we're talking about.
So and I may look to AAG Davenport again, but my understanding is that the pre-application consultation under 301G, which is being incorporated here, does involve the proximate local government. So that's covered. My understanding is there is the alternative in the OGDP rules that we're incorporating of doing a pre-app consult under 301F. And my understanding of 301F is that that does not require the proximate local government. But I will look to AAG Davenport to phone a friend here.
AG Davenport.
I agree with AG Mercer. I'm not sure what I don't have anything more to add.
So again, I'm still confused. I mean, if it's already incorporated in the rules that it would apply, I mean, the rules do say that the 301F does have to meet the requirements of 301G in the cumulative impacts rules. This, and so if it's referenced in 1406, they have to meet the requirements of 301G or F, then the pre-app notice is already part of it. And so I guess I'm not sure what we're debating.
Mr. Chair,
Yeah, go ahead.
it sounds like to me that we don't need changes to the draft rules then in this regard.
If
Fair
I'm
enough.
right.
Okay.
Okay, so sorry for any confusion I might have caused there. So the consensus, it sounds like, is no changes to pre-application notice or consultation because that is already covered as discussed. The next under 1406 is the request from the Southern Ute Tribe to add the Bruneau area as a trigger for tribal notification, but not consultation, is what we heard, I believe, from Commissioner Ackerman. I don't think we heard from the other commissioners on this point, so wanted to hear first whether that's a consensus point, and second, just to get a little bit more specificity, is would it be that a trigger for consultation just if the surface location is within the Bruneau area, or if the subsurface area of review extends into the or underneath the Bruneau area?
Commissioner Ackerman.
Thanks, Mr. Chair. I can go first on that second point and leave concurrence to my fellow commissioners, but I think the intent from the tribe was to ensure that any surface disturbance could be evaluated from their perspective of hunting and fishing. My suggestion would be that this is a surface location trigger.
And I'll wait. So I agree. I'm comfortable if it's a notification only. And I believe Commissioner Ackerman, my notes from your points were, you also noted that it's not a mandatory consultation and there's no special legal standing, were your words, which I embrace both of those concepts as well. So if we want to flesh out that notification and in the SBP put in that other language, I would be comfortable. Others with thoughts? Everybody's saying thumbs up. Mike Cross?
I agree, is all I was going to say.
Okay. All right. I think we've got direction there.
Thank you. Now moving to Rule 1410 on community cumulative impacts and disproportionately impacted communities. We understand that we are to stick with the radius that triggers the no net negative cumulative impact standard from the November 20th draft of a half mile from an RBU, school, etc., within a DIC. And then I just wanted clarity on whether we're adding the words environmental. We heard, I think, from Commissioner Robbins to add public health and the environment, consistent with how it's phrased in the statute. So I guess what we are adding and whether we are adding anything express about economic impacts were our questions.
I can start. I liked just using the language from the statute, and I did not believe, at least this commissioner did not feel a need to expressly call out or not call out economic, but we've got a record that shows that we're talking about not economic. Others with thoughts? Commissioner Oath?
Thanks. And I certainly concur with this language of adding public health and the environment to the regulatory language to be consistent with the statute. I think that makes a lot of sense. With respect to whether or not to say anything expressly about economic impacts, my suggestion would be to add some statement of basis and purpose language, sort of further elaborating this point that because the statutory requirement is that any well that would result in a net negative cumulative impact on a disproportionately impacted community must be denied. And given that the definition of cumulative impact is, then list out the definition, that the commission does not intend to consider economic information in its analysis and determination.
Commissioner Messner?
Thank you. I would agree with you with the turn to public health and the environment. And I think Commissioner Oath's suggestion to the statement of basis and purpose makes sense.
Others with thoughts? Thumbs up? Okay, I could be good with that too. Directions.
Thank you. The next area in 1410 were the specific blue lines, I guess, from associated local governments. Are folks able to read my screen here with this slide? I'm seeing no. So basically, so for 1410A, or let me take this down and then I can pull up their exact suggestions. I think that would be the easiest way to run through these and just clarify. Please just give me one moment. Of course, I had this up and then I took it down. Almost there, sorry. Okay, is that better? Okay, so our understanding in these blue lines on 1410A was the direction to accept all of these changes except for number 2 here, the source of the CO2 and the proposed pipeline route. I can't see everyone, so if anyone feels differently on that, please let me know.
Everybody good with that?
Yep.
Commissioner Messner?
Yeah, I'm good with that. I would like to give staff the discretion to edit it to grab the intent, though, because some of these things that are blue lined in here, are good concepts, but really some of them are captured in other areas as well. Like number 4, any actions taken by the geologic storage operator to first avoid cumulative impacts. There's another blue line section that's not on the screen right now, but that really, I'm just saying that there are opportunities here to combine lines and just make it read better and smoother, rather than having number 4, which is any actions taken by the geologic storage operator to first avoid cumulative impacts, and then somewhere else down further, there's another item around avoidance. Or number 6 is probably a better example, where any actions taken by the geologic storage operator to mitigate adverse cumulative impacts that could not be minimized could be combined with number 9 that says any mitigation measures or community benefits agreements proposed to offset the negative net cumulative impacts. So as long, I guess I just want to allow some discretion to like mix and match some of these things, grab the intent and the words, but just make it flow a little better and make it make more sense.
Staff appreciates that if that's okay with the rest of the commission.
Yeah, I think that's fine. AG Mercer, is this list exhaustive, or is is there somewhere in there that there could be any other information the director deems necessary or something like that? Is that in there?
Don't believe, and sorry, I'll switch over to these are the current draft rules. No, we don't currently have a catch-all of that nature.
I'd probably like to see either that list not being exclusive or, some catch-all. I don't know what might develop, but if we identify in a particular situation something is important, I would not want our rule to be read in a manner that we don't get a chance to take a look at something that's important.
Staff would be happy to draft that unless, is that something we need other commissioners to weigh in?
Are folks okay with that notion? Yeah, nodding of heads up and down, direction
Okay.
delivered.
Great. Then moving to the rest of 1410, we understood there's a desire to adopt the suggested changes in 1410C that just better articulate the mitigation hierarchy. And then in 1410D2 to adopt the blue line there. So essentially everything on this slide except for the change in D1. I don't see any objection. I can move on to the next.
I'm not seeing objection either.
Okay. Is my Word document back on the screen now?
Yeah.
Okay, great. So then still on 1410, we're going to make a clear in the SBP that the qualitative analysis of whether there are net negative cumulative impacts will include consideration of both quantitative data submitted through the Form 50B and other relevant information submitted by the operator. Then there were a couple of questions. One commissioner, and maybe it was Commissioner Messner, referenced the 5-step process that the ALG brought up for this analysis. I wasn't sure whether, staff wasn't sure whether that was a direction to articulate that process in the SBP or what to do with that, if anything.
Commissioner Messner?
So my suggestion was, and I'm going to pull it up here quick, so give me a second so I'm not speaking incorrectly. Is the 5-step process was step 1, review site data to determine area of evaluation and if DI communities would be impacted. Step 2 would be to gather pre-application activities. Step 2 would be pre-application activities to gather community information. Step 3 would be implement an inclusive public participation process. Step 4 was use the mitigation hierarchy to limit impacts. And step 5 would be to use mitigation measures to offset negative impacts. I like the simplicity of that 5-step process. I thought it could be captured in the statement of basis and purpose as a helpful way for applicants to be able to understand how to address this the application itself also could be helpful for us, in reviewing things. I'm not hung up on it one way or the other because it's the way I would approach it anyway. I just thought it was a nice, simple way of kind of looking at 5 of the steps we need to go through as we look at some of this stuff. So,
what are others' thoughts? Commissioner Oath?
I don't know if I have strong thoughts about it either. And so I'm fine adding it. I think we would just want to make sure that as added, it's not like specifying this as a requirement or anything, right? Because the regs do say, you know, these are all the things that, like, this is the process in terms of doing the community meeting and doing consultations, and then, you know, going through that, and then also lays out kind of what our analysis as we're evaluating this, what looks like. And so I'm fine with this as a description of that might be a way for an applicant to go about putting the process and approach. But just, I guess those are just thoughts about the kind of context of how it would fit in my mind.
Well, and listen, it could be a guidance document as well. I just wanted to capture. I thought it was a neat, a neat, simple way of looking at things.
I like that last thought, Commissioner Messner, as a guidance document, and then it doesn't like become like it's the only way to go about doing something, which we would have to kind of explain away in the SBP. Is everybody okay with that? Direction given.
Thank you. The next point is we did hear a general consensus that we do not want to sort of proactively adopt the social cost of carbon as a metric that needs to be used. But staff wasn't clear whether we were supposed to say anything about it, for instance, in the SBP.
Thoughts, Commissioner Oath?
Yeah, thanks. I, for one, do think that it would be helpful for us to be really clear in our intention in the statement of basis that we do not think that the social cost of carbon is an appropriate tool for quantifying environmental benefits on the local community in this kind of context.
Everybody good with that? All right, direction given.
Thank you. We're getting almost to the end. 1411D, the consensus is to eliminate the phrase prior to constructing a geologic storage location from the beginning of the provision requiring a surface use agreement. Then Rule 1415, we heard from at least one commissioner the preference to add back in self-insurance, letters of credit, and taking out the government-backed securities part of the other one that we removed. But I didn't think we had a full sense of where all the commissioners were on that.
Commissioner Messner?
So I would prefer to see the language stay as is, or even closer mirror the language that's currently in the Act that indicates that self-bonding is disfavored. I mean, it's a statutory language. It's pretty clear as to things that are favored and things that are disfavored as far as financial assurance goes. Some consistency between this and the Oil and Gas Act makes some sense to me. I'm also fine just leaving it the way it is currently in the draft, understanding that under the Act, they have opportunities to, in the current draft, they have an opportunity to suggest a financial assurance mechanism like self-bonding or letters of credit, but that it would be disfavored under the Act as applying the Act to that. And so I don't think that it needs to be explicitly allowed.
And I'm probably in a little bit of a teeny different place there. I see CCS projects as not being the same as oil and gas projects. And I can understand the self-bonding or whatever being disfavored. I mean, at the end of the day, I like the fact that ultimately we're not precluding anything, and it's really up to the director and or us as we look at a project as to what the financial assurance is going to be. So I don't need it to be expressly stated. I also don't think it needs to be disfavored. I think it ought to be an opportunity on a CCS project by CCS project basis. And it's ultimately up to the discretion of this commission as to what we're going to allow or not allow. I don't know exactly how to write that, and I don't know if I'm in the majority on that, but those are my thoughts. Commissioner Ackerman?
Yeah, thank you, Mr. Chair. You hit on the key point for me in that I think the opportunity needs to be there. I do think that it's important to point out that it's disfavored. I think about it more from a procedural perspective of compliance with the statute, but also the concept of being able to pass a at least as stringent review from EPA. So the closer that we can get to the EPA language and still maintain those sentiments is where I lean.
Commissioners Cross and or Oath?
I don't know if I have anything helpful to say. I don't have strong opinions on this. And I think I could be fine. It does seem like it's more of a procedural thing in what we're debating, right? I think we all agree conceptually that these particular types of instruments are not to be favored, but could be utilized depending on the circumstances, and ought to have a closer look. So I'm kind of agnostic on whether or not we say they're disfavored, whether we explicitly allow them to say they're disfavored, and that they come to us if the staff has some concerns, or whether we say they must proactively go in front of the director for review before being explicitly allowed.
Commissioner Messner?
Yeah, just to be clear, I'm advocating for leaving the November 20th draft alone. The disfavored piece is already in the Act. The 1400 series are part of the Oil and Gas Act. The disfavored concept is already incorporated into it. So, in my understanding, so I would just leave the November 20th draft alone.
AG Mercer, can you help recollect my recollections? Does the November 20th draft allow it? I think it doesn't call out the various types of financial assurances, and it's just really up to the operator and what they decide to present, and then it's up to the discretion of the director.
Close. So here, let me pull up the November 20th draft. So here, let me see if I can make this a little bigger. So can folks see my screen?
Mm-hmm.
So 1415A1 is where there's a list of the financial responsibility instruments that can be used. This is EPA language, but the EPA regulation also has three differences. Included on the list and removed in staff's draft is self-insurance, letters of credit, and then for irrevocable trust funds, we added this language with government-backed securities. So there is, of course, this catch-all in letter F, which is, again, EPA language that allows any other instruments satisfactory to the director. So EPA's regulations list out self-insurance, letters of credit, and irrevocable trust funds as acceptable mechanisms. Staff removed or tweaked those while retaining the catch-all.
Okay. And again, I don't know if I'm in the majority or not. That last clarifying point, catch-all, is satisfactory to me, provided that that could mean some of those other things in a case-by-case basis up to the discretion of the director. Is everybody, Commissioner Cross?
Thank you, Mr. Chair. I agree. As Commissioner Ackerman said earlier, I like keeping it close to what EPA has. I do think the catch-all works. So I by no means a hill to die. I don't really feel strongly either way. I think Commissioner Oath's right. I think we conceptually are all in kind of the same place here. So I think the catch-all is fine.
Okay, then are we all comfortable just leaving the language as is with no further edits? Okay,
Okay, thank you.
back to your work.
Just a couple things left. For 1420L, which is seismic monitoring, there was a request from, I believe it was Carbon Storage Solutions, to use the SBP to provide more detail on when the 24-hour reporting clock for a seismic event starts. That was one of staff's recommendations of suggestions that we adopt, but I don't believe we heard from the commission on that. So we wanted direction there.
And you just said staff was okay with that suggested edit?
Yes.
Then I'm fine with it as one commissioner. Commissioner Cross?
Thank you, Mr. Chair. And I too am fine with it. And I think I meant to say that during my deliberations. I don't think that we need the definition change that was proposed with respect to the minimum credible magnitude, I think is what it was. I don't think we need the definition, but I was fine with the statement of basis and purpose language.
Okay, thank you. I think I saw nodding heads, so we have consensus there. The only other 2 points we had were sort of miscellaneous items for the SBP. So one is, it seems everyone's in favor of making sure that there's plain language on the ECMC website, sort of explaining what these rules are for, which was a Green Latinos suggestion. And I didn't know if that was something the commissioners wanted staff to put into the SBP, or if that's just direction to staff for when these rules are posted.
Commissioner Ackerman?
Yeah, I'm happy to weigh in on this one. I think this would more commonly fall under direction to staff, in my opinion. I'm not sure that, we do kind of have a standing policy and improving policy of plain language. And certainly we address that in the cumulative impacts as well. My preference would be just to, not only with regard to this, but to encourage staff to include plain language on our website, and particularly as we're dealing with complex issues. So I don't necessarily have an objection to putting it in the basis and purpose statement. I just think it fits better as more of a directive comment.
Others with thoughts? Everybody good?
Okay, the last one was adding language to the SBP, just clarifying that any confidential business information in applications will not be made publicly available. I believe that was a suggestion from one commissioner and we didn't hear from others, so just wanted to confirm.
Commissioner Ackerman?
Thanks, Mr. Chair. And I don't mean to put you on the spot, AAG Mercer, on this one, but is this one that's otherwise accounted for already in statute and or regulation?
Yes. Well, generally, yes is the answer. That, operators under our current rule, I believe it is, well, I couldn't quote, I think it's 223, have the ability to indicate any submissions that they're making that they are asking for confidential treatment of. And there are a list of criteria under which they can ask for confidential treatment, which include confidential business information. And then there's a process for the director to take a look at it, make sure that it's truly entitled to confidentiality. And then it would be if it's on a form or something that is public, or that would be public facing, it would be redacted. And then the commission staff would maintain confidentially an unredacted version so that the agency has all the information, but the public facing is redacted. So yes, I believe our existing processes already take this into account.
Thank you, AAG Mercer. And some concerns were expressed during testimony along these lines, that there's significant expense that goes into the development of these processes and technologies. I don't necessarily, I'm not opposed to, certainly I'm on board with the concept of appropriate protection. Not necessarily opposed to putting in the statement of basis and purpose statement, but it does give me pause when there are other controlling factors, and certainly don't want to be in a position where we're influencing overall policy, or differing from overall policy as a result of what we put in the statement of basis and purpose. And I recognize, Mr. Chair, that I didn't really propose any direction there. And so I think, I would lean towards leaving it out of the statement of basis and purpose, just for cleanliness. But again, I'm open to discussion.
Commissioner, if I may add, I just remembered that we actually also directly addressed this in our 1400 series rules. 1405E confidentiality states if the operator designates any portion of its Class 6 development plan application as confidential pursuant to Rule 223, then the director will post only the redacted version when the application is posted. So it is also in rule.
Thanks for pointing that out. And that seems quite clear to me, addressed in a regulatory manner. And so again, I think I would lean towards leaving it out of the statement of basis and purpose.
Commissioner Messner?
Well, I would agree with Commissioner Ackerman. And I do want to just, so we don't move, because I know this is our last thing. I do have one do-over. It's a small thing. It's really more of, I think, a typo that I wanted to mention. And I guess I feel like I have to do it now, before the drafting happens. And so I just want to give you a heads up that at some point I want to bring that up.
Yeah, I've got one other topic as well. So, AG Mercer, before we move to potential additional topics, is there anything further that you and staff feel you need from us in terms of direction?
No, thank you, Mr. Chair, and thank you to all the commissioners. That was everything on our list. So just if sounds like there are a few other items, we are all ears.
Okay, great. And really want to thank staff for the hard work over lunch and putting together a very understandable deliverable there in terms of what our direction was. You do a very good job of capturing what we're thinking, probably more so than we do. Commissioner Messner, your slight additional item, typo.
And this is one that I had brought up with staff in individual discussions, and I just forgot to mention it in this process. But hang on just a second, I'm pulling it up. In Rule 1405A, it states, and maybe AG Mercer, you could bring that up on screen so that it's easier for folks to see. But it states in there that prior to commencing operation of a Class 6 and UIC well, and so I read that as that they can begin construction before having a permit. I know that's not the intent, and so I wonder if there's some other word besides operation that could be used there that indicates that no activity should happen until the permit is in hand.
Thank you for bringing this one up, Commissioner Messner. And what you're looking at on my screen is our sort of red line, where after we talked to you last time, I put in construction or operation as a potential red line to suggest to the commission and then forgot. So let me know if that addresses your concern. And of course, we're here to take commissioner direction though, so it doesn't need to be how I wrote it.
Well, that's fine with me. I just didn't want to forget it. And then my only other, well, I guess I'll wait and see if other commissioners agree.
I'm fine with it.
Yeah, same. I think that makes sense.
And then my only other one, and let me just get it up here again. I think is 414. (1426A). All right, I'm not seeing it now. I saw that at some point there was a duplication there in one of the drafts, or maybe I was just misreading it when I wrote it down, but I don't see the duplication now, so never mind.
The only other thought I was pondering, as with so this has been a long and weighty rulemaking. It's very subject matter oriented. we are doing it to achieve one goal of obtaining primacy from EPA under the Safe Drinking Water Act for Class 6 UIC wells. And then sort of the second component was to implement the statutory directive to create a protective and safe protocol for Class 6 for the state of Colorado to encourage CCS projects. One thing that I heard a little bit of from stakeholders, and one thing that I heard from just discussions with stakeholders, is this is not a sort of static thing. We may need, as we go through the primacy application, to revisit the rules, to make some edits to make sure that we get primacy. And then as projects develop, we may need to make revisions and revisits to ensure that the second goal is also being met. That's me talking. I believe that to be a true statement, or those to be true statements. Is that something that we need to tuck into the beginning of the SBP or at the end, or is that self-evident, or am I the only one thinking along those lines? I throw that out there for everyone's consideration. Commissioner Oath?
Thanks, Mr. Chair. I had a note about that as well, that I think at least one of the parties did ask us to add some statement of basis and purpose language indicating, that this is an iterative process and that we would expect and anticipate coming back to potentially make some changes, which to me is a true statement, but as you said, is also a bit self-evident, right? All of our rules are always something that I think we would consider, for updates as we gain more experience and as factors change. So that is maybe a not very helpful way to say. I've had the same thought. Could see that there's merit either way of acknowledging that explicitly or noting that that's kind of always the case and not needing to be explicit.
And the only reason I kind of bring it up in this instance is this is a little different in that the first goal of achieving primacy is kind of a chicken and egg sort of thing. And so the need for perhaps revisions to make sure primacy is met may be more evident in this instance because we are working with, the federal government and the EPA. A.G. Mercer, not to put you on the spot, but I'm putting you on the spot. Do you have thoughts about this concept and whether a sentence or so in the SBP would be helpful or redundant?
I think staff is happy to go whichever direction the commission would like. I think, as you've all acknowledged, the commission always has the authority to open up a new rulemaking if changes are needed. So I don't think we need to say it in order to keep that possibility open. But if it could be a helpful clarification, staff certainly wouldn't object to it.
I still kind of like it. I mean, I think it's sending the right signal to the EPA, if nobody else, in terms of, us, having an open mind to make sure that we achieve the goal of obtaining primacy. So I would be in favor of some, some language that tries to accommodate what I first said. Commissioner Ackerman?
Thank you, Mr. Chair. I agree. And I mentioned this with regard to the known adverse impacts discussion that it would need to be iterative, but I feel the same way. And I also think it's, besides the points that you raised, it's bolstered by the fact that this is an inaugural rulemaking to establish a program from one that didn't exist. And so I do think that acknowledgement of that and recognition that we may have some iteration going forward is appropriate.
And I like that last point. If you could weave that into the language, I think that would be helpful as well. Does anybody have heartburn with these notions? All right, seeing none, let's add a little SBP language along those lines.
Will do. Thank you.
Any other areas that we need to be talking about today? All right, seeing none, I believe we need to continue this to next week. I did touch base with Hearings Manager Thomas And I also touched base with staff in terms of the time to sort of generate a new draft and get us a chance to look at it. Our Wednesday meeting next week is very light. We have a report and that's it. And since we're going to be together that day anyway, I would suggest we continue this to Wednesday, December 11th. And then the other piece, and AG Davenport may visualize himself, is the ever last question of leaving the record open or closing the record. AG Davenport, do you want to remind us what either of those actions equates to?
Happy to, Chair. By closing the record, the commission would be foreclosing any substantive communications with either the parties or staff until possibly next Wednesday, when the commission would have the option to reopen the record and have substantive conversations at that point. Keeping the record open leaves open the possibility of having those substantive conversations. Of course, those would be individual conversations between commissioners and staff or parties.
What's y'all's pleasure? Commissioner Messner?
Well, I'd like to close the record myself.
Huh. Okay. Anybody else? You want to move?
I can. I move to close the record. I don't have the docket in front of me, but on this docket.
I'll second that motion. Any further discussion? Seeing none, all those in favor signify by saying aye. Aye. Any opposed? Motion carries. And then I think just the last order of business is to move to continue this rulemaking. I don't have the docket number ahead of me either, to December 11th at 9 a.m.
Second.
Motion and a second to continue the matter to December 11th at 9 a.m. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Okay. Well, one last procedural matter. AG Mercer, sorry, I'm calling you up again. Can you give us and/or all of the stakeholders, 43 of them, a sense of when this new draft in the new SBP will be daylighted and how? Like, is it going to go into the e-filing, et cetera, so that way our stakeholders as well as commissioners can know to go look for it and review it?
Thank you, Mr. Chair. Staff, if this works for the commission, our intent will be to have that ready on Monday. So by the end of the day, Monday at the latest. And then staff would e-file that so that all parties would receive a notification. And then I believe the typical practice is that the hearing officer would also add it to the docket that's available through the ECMC website. We could also ensure that it is those documents are emailed directly to the commissioners as well.
Excellent. All right, everybody, that's what's going to happen. I appreciate the work of everyone this week, including the parties and the stakeholders, and including staff. Once again, a serious commendation to staff for the good work here. And with that, we will adjourn and we will see everybody on December 11th at 9 a.m.
Thank you.